Appeals Court, Sidelines, State Authority. Welcome to Law and Society. Please subscribe, and let's talk about the Ninth Circuit's ruling that put a permanent stay on the district court's order for Donald Trump to turn over California National Guard back to Gavin Newsom. Well, I believe that the Ninth Circuit made a mistake, and I believe that it made a mistake in interpreting the statute, and because the statute, and I'll read it to you, is very clear on the procedure of how this law would be applied. So the law is 10 U.S.C. Code 12406, and there are three instances in that law that would allow the president to federalize the National Guard. In this instance, it is because of subsection 3, and it says that whenever the president is unable with the regular forces to execute the laws of the United States, the president may call into federal service members and units of National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. The orders for these purposes shall be issued through the governors of the states. So, what the Ninth Circuit essentially said was that, the president definitely has authority to deploy the National Guard and federalize the National Guard should they be unable to use regular force and execute the laws of the United States. So here in this case, what is Donald Trump executing? Donald Trump's DHS is not executing judicial warrants. They're not even executing immigration warrants. What they are doing is they are picking people up in places like Home Depot or in farms or in other locations where there may be likelihood of undocumented people, and they're just picking them up and detaining them. So in the first instance, I don't know why California didn't sort of argue this, so it's nowhere in the argument. I find it that in the instances that these ICE agents are waiting outside of the immigration courts, and when someone's case is dismissed, are taking them into custody right away, generally the court gives these people reasonable amount of time, about a week, to wrap up their affairs before they can self-deport or report somewhere where they can be deported. Well, that's not the procedure that they're following. They're just picking them up right then and there. So it's not following the immigration court orders. It's not following any judicial warrants. It's just going in. So what exact law under Section 3, the president is unable with the regular forces to execute the laws of the United States? What laws is he executing when he is detaining people? And that is the general premise on which the bringing and federalizing of the National Guard is being premised upon. So the president actually has to execute certain laws. In these raids, and I call them raids and not searches under, legitimate warrants, because there are no warrants. And if that were to be the case, that there were warrants in all of these cases, we wouldn't be hearing about it, because then these people would be given due process of law. So that part is not even brought up by California, and I don't know why they didn't bring that up. The second thing is that the Ninth Circuit says that when in the statute it says orders for these purposes shall be issued through the governors of the states, that is not a statement that clearly infers that the governor has to give consent. I mean, the orders for these purposes shall be issued through the governors of the state. So, whatever order is being issued, what happened in this case was Donald Trump told the Department of Defense to issue orders to the National Guard, and that be transmitted through the general who is in charge of the National Guard in California. And in this case, the Ninth Circuit holds that that general relenting command and then notifying the governor is sufficient to satisfy the shall be issued through the governors of the states. Because it says that this subordinate officer, who is the general who is in charge of California National Guard, has received this communication from the executive saying that we are going to federalize the National Guard. And so that general has said, this is the order from the federal service, so I am going to have to follow this order and then notify the governor of the state. But it didn't go through the governor of the state because the general didn't notify the governor, and the governor then didn't go and clear the general from to federalize the troops. You see, the governor didn't give that order, so orders for these purposes shall be issued through governors. The order was given by the Department of Defense to the general, who then gave up command of that to be federalized, and then sent a notification to the governor. The governor didn't issue the order through his office. That movement didn't happen. So, I believe that the Ninth Circuit made a mistake, and it sidestepped state authority, because if that is all, letting the subordinate officer know that you are going to federalize the National Guard is all the president has to do, then what is the purpose of the statement that orders for these purposes shall be issued through the governors of the state? That's what's in the appeal, and that's the part that is the contention here. And I'm hoping and I'm thinking that Governor Newsom is now wondering whether he wants to appeal to the full Ninth Circuit, called the en banc, or to take it to the Supreme Court. And there's a point in this case that the Ninth Circuit talks about how the judiciary has to give deference to the executive in executing the laws and to having the power to call into federal service units of the National Guard. So, and with that, I would like to personally say that the president is unable with regular forces to execute the laws of the United States. What laws are these masked people who are claiming to be ICE agents doing? What execution of what law? Are you executing a warrant? Where's the warrant? Comptroller, I think Lander, was also manhandled and detained for a few hours, I believe, because he was accompanying one of the people whose cases were dismissed in immigration court out of the immigration court so they could go back to their families and prepare to be leaving the United States. Well, that person was disappeared right then and there without, giving that person the time to, take their belongings with them. This is how inhumane and cruel DHS and ICE and Border Patrol is being. And so there are so many issues with the Ninth Circuit's ruling, primarily them saying that nullifying even the importance of letting the governor at least acquiesce to that order coming down from the Department of Defense. But in this case, the the Ninth Circuit says, no, that in this case, the government is likely to win on the merits because the president has the power to federalize, and he did notify the subordinate general, and that qualifies as orders through the governor's office. That, I think, is a misreading and wrong reading of the law itself, the letter of the law. And I guess it's a decision that lawyers, Gavin Newsom's lawyers and California's lawyers, the AG would have to determine whether they want to contest this or not. Because I believe that if they don't contest it, at their relenting state power, and also in many ways the rule of law, because it is, I believe, a wrong interpretation of what the law says. And I would like to see the appeal be made to at least the full Ninth Circuit, if not the Supreme Court. With that said, thank you for listening. Please like and subscribe, and I'll talk to you soon.